So hi everyone. This is the third part of my lecture series that I'm continuing on jurisprudence, and it's on the nature of law. And this lecture is basically about I'll discuss about the functional theory of law and how its implications are vis-a-vis the authors of the modular conception of law, the famous being Hart, and the functional theory of law being Fuller and Dworkin. And Fuller's theory, I'll extend it with Simmons and Nigel Simmons and John Finnis's another two recent famous legal philosophers' theory about how they extend Lon Fuller's idea. In this video, we will go systematically, so let's buckle up for the ride. And the first thing about Lon Fuller I'll talk about. So he says that law is like a saw. So I have discussed in my previous video that we have to either consider law like a Swiss Army knife, which basically is a modular conception of law, that it can be used for a variety of purposes, not specifically for cutting or any vegetables or fruits, but you can also use for murdering someone. But for Fuller, the exercise is very particularly specific. So he says in his book The Morality of Law that law's purpose is central to understanding its nature. So what is the purpose? The purpose of law is to subject human conduct to the governance of rules. Now, Fuller's main argument was that the criteria by which his view is that we determine whether law exists are only intelligible if one presupposes that law has by its nature the purpose of subjecting conduct to the governance of rules. This, particularly the presupposition to governance of rules, he calls it the 8 desiderata or the principles of legality, which are that there must be rules, the rules must be published, the rules must be prospective and not retrospective, with which it is possible to comply. They should also be intelligible, they should be non-contradictory and reasonably stable across time, and officials must act in accordance with the published rules. If there is any departure from these criteria, then it cannot be said that a legal system is in existence. So we would simply, so for Fuller, or if we ascribe to Fuller's theory, we have to simply ask to what end is the law defined, so that it cannot exist without some minimum respect to the principles of legality. And to that question, his answer was the law's end or law's purpose is the governance of humans' conduct by rules. Only by postulating that this law's purpose is, do we make sense that our settled understanding that law exists where there are rules which are sufficiently clear, prospective, non-contradictory, and prescribed and prospective, and all the other desideratas that I have pointed out on the principles of legality. So his basic purpose is that the principles of legality must be ascribed to a minimum standard for which a law, if it has to be elevated to a law in a legal system, must be ascribed to for the presupposition to exist to satisfy the ultimate end, which is the governance of the society by rules. I'll point out how Fuller and Hart are distinguishable from, it's a very terminological basis, because the idea of Fuller, if you can note it from his notion of purpose, is that he says that the central task of jurisprudence is that we need to understand why law is important, why law officials are needed in the human society at all. So in his first book, if you have read The Law in Quest of Itself, he criticizes contemporary jurisprudence for its failure to address the purposive question of law, why lawgiver is needed at all. So I'll explain in a future video about Fuller's thought of law purpose governed by rules is intrinsically moral one. So this is a very highly controversial claim that he makes, because if you consider the modular conception, because if something is instrumental to morality, if it is already said by the positivists, to completely consider the entire enterprise to be a moral function is something which is very narrow-minded in my sense, but I'll come to that later. I'll come to this distinction between Hart and Fuller in this video later. So Fuller's functional theory has been built on by two recent legal theorists. One is Nigel Simmons and the other is John Finnis. Now Nigel Simmons says law is like a triangle. Now you have seen a triangle. If you draw a triangle in a piece of paper, on a piece of paper, it will be imperfect. Mathematical textbooks can also have precision wise a very good triangle, but it still will be imperfect. Now the fact is that why triangles are triangles and why law is like a triangle according to Simmons is that by virtue of their approximation. So they closely approximate to the mathematical definition of a triangle. That's what law according to Simmons' conception is. Consider the concept of bachelor. Bachelor is someone who is either an unmarried man or he is not. It's basically he distinguishes the two concepts into an archetypal concept and a class concept. The archetypal concept being ascribed to the approximation part of the law as triangle, and the class concept he ascribes it to the bachelor part of the conception, which I have explained through the example. Now I'll delve deep into the archetypal concept. Now Simmons describes law as an archetypal concept by virtue of its approximation to the abstract definition by nature of degree. So in Simmons' view, when something counts as an instance of law, firstly it depends upon to the extent of which Fuller's desiderata is complied with, and the more it counts towards the legality principle, the more it exhibits, the more it extends towards it, the more it counts as a law. That's what Simmons' central thesis is. So law's archetype then involves conformity to Fuller's desiderata. However, according to Simmons, this is only the first layer of understanding, because to the extent of understanding Fuller's desiderata is something which Fuller also ascribes to by virtue of it being a purposive moral aim. But his theory of archetypal concept goes a bit higher to a second layer, and that second layer is that law is like a triangle. It differs according to Simmons insofar as law's archetype is a moral aspiration. Now what is this moral aspiration? It is the compliance of Fuller's desiderata to the intelligibility of realizing the idea of liberty. Now complying with desiderata is sufficient extent, but the necessary conception which according to Simmons' archetypal concept comes in when it confers a distinctive kind of liberty on persons subject to the law. This is because a system of rules announced prospectively with which it is possible to comply will always grant subjects some options as to how to comply with the rules. For example, the law might require the person to drive on the left hand side of the road, but to the extent of which he is doing that, he is firstly fulfilling the archetypal concept of the Fuller's desideratus concept of principle of legality, that he is driving on the left hand side of the road. But whether or not that person while driving the road has an aspiration of a liberty, that is what he wears. Let's say he wears a hat, or he's smoking a cigarette and he is driving. So these things will not count in the aspiration of law, because that's the central thesis of liberty that a person has when he's driving, because the main focus here is the rule prescribes that you have to drive on the left hand side of the road. That is simply the prescription of the legality that Fuller also talks about. Simmons goes to the next extent to say that if the principles of legality are satisfied to the extent to which a person's liberty is also assured, then we are saying that the law is also ascribing to have a moral aspiration. So in short, we can make sense of law's archetype where we come to see as it is geared towards serving some liberty. Now how does it distinguish from the concept of class concept? Is that if you consist of a class concept, if you understand a class concept, if you meet a certain criteria, then you will be considered that person or considered to be satisfying law. If you don't meet that certain criteria, then you will not be considered that person, or you will not be considered satisfying that law. It's a very black and white situation of a class concept is. But the archetypal concept is a much more grayish matter. Okay. It basically says that you have to follow the principle of legality, being a class concept, that you have to enter into that criteria. but to the extent of aspiration of the person's liberty that is satisfied and that is ascribed to the degree of approximation towards the person's fulfillment of the liberty. That is what is called as Simon's second layer, and which is by his archetypal concept makes it a very greyish matter. Now we will come to the point that we think of law as a mundane instrument. Now, why does Simmons basically considers law as an archetypal concept and not a class concept? He has given 3 reasons for it in his book Law as Moral Aim. So Simmons' first point is that the rule of law, which Simmons writes, he says that governance by law is regarded as being in itself a virtue of a just political community. We tend to think of rule of law as an ideal or an aspiration. Of course, it is an ideal or an aspiration, because rule of law is just the situation where we say the law rules. That is basically what we are saying. So, if it is right to think the law and rule of law are deeply connected, and rule of law is the aspiration, then there is a deep connection between law and the ideal of aspiration, which is the rule of law. So, this is his first argument defending why we need to have an archetypal concept in the first place. Second is, law is invoked as a justification of a sanction-oriented concept. Now, the fact that a person has breached a rule of law rather than some other rule is thought to be crucial for justifying the outcome that the person should be sanctioned. Simmons says that this ordinary understanding that we have of the way that law is invoked by judges to justify sanction cannot be simply referenced by virtue of a master rule of recognition which Hart has set through his rule of recognition. It would not be intelligible for a judge to offer as a justification for sanction the fact that a person has breached a rule which is identified by rule, which the judge purely follows it by selfish or malicious reason. You're getting me? So basically what Simmons is trying to say is that if simply a judge is to mechanically apply that whether or not a rule has been violated by a person by looking at the master rule, then that would not ascribe to the aspiration of a judge itself. So he is also talking about a liberty of a judge's standpoint, the liberty of the judge's standpoint to have an ideal to choose whether or not which law is ascribing to that liberty with which the judge is ruling on a particular sentence or basically justifying it as a sanction. That cannot be itself referenced on the ground of a rule of recognition by Hart. So implicit in our ordinary understanding of law according to Simmons is that the idea of law has a special moral quality that it could justify imposing sanctions on a citizen. So for him, this is the moral ideal. The judge's aspiration is morality. That morality ascribes the judge to have the liberty to basically decide upon a person to justify whether a sanction has to be imposed on him or not, is not simply referenced on a master rule of recognition but on morality. So his whole enterprise is also again talks about law as a moral aim, but his talking is a bit slightly different because fuller, because he references it to an existence of a degree or an approximation to which he says the law is an archetypal concept. Third is the doctrinal argument, which basically says that the aspirational aspect of our understanding of law is also revealed when we consider doctrinal argument about the law in a particular case. So textbooks writers often offer as claims about what the law is propositions to have neither been authoritatively determined by the courts. For Simmons, these kinds of claims can be understood as an attempt to move our understanding from particular rules or doctrines towards the archetypal concept of law, because there is neither an authoritative base on it. That is why I'll give you an example. Let's say a particular law is applied and you simply cannot apply it on the basis of what the law states. So you have to look at the preamble, you have to look at the textual conventions, we have to look at the conventional understanding, you have to look at judges' originalistic or a living constitutionalist viewpoint. So these all ascribe to a moral aspiration which the judge has as its liberty to decide from, rather than simply referencing his decisions on the basis of a master rule of recognition that has been recognized by the officials or who have been part of this synthesis between primary rules and secondary rules. This is the argument with which he wants to differ. However, this argument is slightly also controversial, because then you are singularly defining the term that judge's aspiration is something which you are looking at it from the ideal of a judge's viewpoint. You are not you are disrespecting the authorities of legal institutions and others. So I'll come to that arguments of the fallacies that I've identified from these claims which these natural lawyers have made. So there is also a particular discussion that I want to talk about in the next video, in some other video if I can, that is the aspiration of rule of law being morally neutral or not. So here there is a jurist called Matthew Kramer who distinguishes from Nigel Simmons. So Kramer claims that departures from rule of law is general tends to weaken incentives for the compliance with the law. So even if that law is wicked, consequently, even if a wicked legal regime has good prudential reasons for complying with the rule of law, that to that extent we can say the rule of law is morally neutral. Because if a Nazi Germany enacts a law and if that law doesn't ascribe to the morality standards of a judge who is deciding upon a case whether or not this rule ascribes to the rule of recognition of Nazi Germany, so they have good and prudential so wicked regimes, though simply by their existence, have also good prudential reasons to exist. Where Nigel Simmons distinguishes and disagrees, he says that departures from rule of law generally do not tend to weaken the citizens' incentive to comply with the wicked legal regime's objectives. So the legal regime in his sense, it has no particular reason to comply with the rule of law. Consequently, incentives for compliance have no particular bearing on the moral status of law. So moral status of law is something which is different from a citizen's or from a legal system's incentive to justify whether or not it complies with the morality part or not. Which Kramer says that it is morally neutral because they also have prudential reasons rather than moral reasons. But Simmons says that there are these moral reasons for which a law is to be diversified or distinguished is something which is so this incentive for compliance has no particular bearing on the moral status of law. Now let's come to John Finnis. Now John Finnis says that law is like a house. So for him, the law's purpose is central to the understanding of law's nature. That's what Fuller and Simmons Enterprises also talks about. But where he distinguishes from Simmons and Fuller is that law's understanding is not simply to exist to guide people's behavior. That is too thin. Because the purpose of having law is not just to guide people's behavior, but to guide people's behavior in order to enable people to participate in the sort of states and activities that is good for human beings to participate in. These goodness of life with which a citizen participates in and has the capability to participate in are such as life, knowledge, play, marriage, friendship, aesthetic experience, spirituality, practical reasonableness. So for Finnis then, though this is not a comparison, he himself made that law is like a house. So when you simply look at a house, and if you consider it in functional terms, you are saying that the occupants are only living under it because they have a roof over their head, is to best offer an account of the nature of the house is just as thin and impoverished as Fuller's account of purpose of law is. Because if you have a house, the function of the house with which you are supposed to use it. So there are many ways with which you can design a house, and you can enable the occupants of that house to enjoy the goods that the occupants of that properly designed house will enjoy. So basically, let's say if a house is supposed to be ascribed to a particular function, which according to Finnis is that it needs to have an architect, someone who will decide how the house is to be designed. In the same way, there are thousands of different combinations of law that would work equally well to enable the members of a particular community to enjoy goods that law exists to enable them to enjoy. So if a legal system is to operate in the way it's supposed to do, someone or somebody or some combination of bodies needs to determine what combination of laws will be given effect to by that legal system. We will discuss Finnis's theory in greater detail. So, in short, if I may summarize what Finnis is saying, as opposed to what Fuller and Simmons' viewpoint is, that for him, participation of the person in that particular house, let's say that house of cards or a house of law, is that how you participate and how you flourish in that house is much more important than simply stating that the purpose of that law is to serve as a house that is have a roof over your head. That is very impoverished and a very thin concept, which Finnis doesn't agree towards. Now let's come to the second part of functional theory, that is of Ronald Dworkin. I have in my previous video have said that Dworkin considers law as an interpretive concept. So I'll now discuss deeply into Dworkin's theory, though his theory has been distinguished between Law's Empire and Justice for Hedgehogs. So I'll focus on Law's Empire because Justice for Hedgehogs consideration, he basically says in that enterprise, he says the law is a branch of morality. Now that's a very controversial statement that Dworkin uses, and it's very fallacious also, and I'll point out to you in this video with a couple of points which I have analyzed from Dworkin's arguments. So I'll talk about it, and I'll talk about this part about law as a branch of morality in some other video. So according to Law's Empire, Ronald Dworkin's theory is that law is an interpretive concept. The function of law is to insist that force be used only to an extent that it is justified by past political decisions about when collective force is justified. And third is that the law in a system consists of the best moral justification of the past political decisions of that system. Now, Dworkin introduces his theory by developing a story. He has said it in the book as well. I am also summarizing what he says. So he has talked about his theory from the concept of a courtesy in an imaginary community. Now this story has two stages. Stage one, at this stage, the community follows a set of rules which they call rules of courtesy in certain social interactions, like the courtesy to basically, when you look at an aristocrat, you basically take off your hat and you bow. When you see a king passing, so you bow. Or you say hello to a neighbor or a stranger when you're in a Western country. So these are all signs of nobility and kind gestures. These go largely unquestioned because it is a character of taboo that if the community thinks that the rule of courtesy just ought to be followed. Because if it is not, then it is considered as a taboo. So stage two, he develops that the community develops something what he calls an interpretative attitude. So this attitude has two distinct components. One is that it involves an assumption that the practice of courtesy has some point or value or purpose, which can be stated independently of simply describing the rules of courtesy themselves. It involves a further assumption that what courtesy requires in a particular situation is not wholly determined by what people have thought courtesy requires in the past. Rather, the requirements of courtesy are sensitive to the point, value, or purpose. So I'll give an example to what he says. So consider again the rules of football that I've used in my previous video. Now you may argue that we might appeal that a particular game of football has some value, as we say that the spirit of the game that we consider, that the rules of football, if a particular rule, let's say a VAR system has been introduced, so it ought to be changed because it is unfairly treating a particular footballer from exercising his choice freely, because what he considers at that instance much more than artificial intelligence mechanisms, human interventions are much more important. But I also argue that VAR as a system something is which I say is very essential, because you are not only using artificial intelligence, you are in fact using a human intervention behind it, just to note as a decision whether or not that final decision stays with you, whether or not you agree whether that decision of giving a penalty or not needs to be communicated to the referee, so that third referee has that particular freedom to do so. So he's simply saying that he violates the rule of law, or violates the VAR rule, and therefore he should be penalized, or the footballer should be penalized, or the team should be penalized. I believe that VAR as a system is something which should exist. Now I have deviated. So what I was talking about is is that rules are determined by what an institution like FA says or UEFA says. If, however, we adopt what Dworkin's interpretative attitude is, or what the community thinks the interpretative attitude means, we are then saying what the rules of practice currently are, not what they ought to be. So here Dworkin is going in a descriptive basis. He is not going into moralistic basis of understanding rules as they ought to be, but he simply considering rules as descriptive as what they ought, as what they are, rather than going normative as to what they ought to be. He says the point which he says is that it is directly determined by the point, value, or purpose of the practice, and not just by anyone who actually says that the practice is required. So his focus is not on the political actors that I pointed out in my previous video, wherewithal I have said that this ground is highly controversial because it disappears the notion of a legal system's authority by simply teleologically extending the purpose to the value of a rule in a system, that the point or specific purpose for which it determines that is much more important rather than the institution which says that this rule is important or not. So it is very hypocritical, or I would say very obnoxious, to state that if a VAR rule has been introduced, that has to be introduced or given validity by some institution. Otherwise, then every football competition, why doesn't it have VAR? And even if they had VAR, even if they didn't have VAR, then who basically surmised this theory of having a VAR in the first place? How did people themselves want them, like a fan wants him for himself that his team be in a negative position? An institution has to create something. They have to be very neutral in this aspect. As a secondary rule, they need to enforce whether or not the primary rules ought to be obeyed or not to be, or to be disobeyed. So his theory is very necessary in the sense that law is something which has a very value-based, purpose-based, teleological-based perspective, which basically I point out that it shouldn't, because law's purpose is not simply necessary, but as a contingent matter has to its validity that needs to be determined by a rule of recognition that is determined by a particular institution or convention that requires it to have this broad-based consensus. Because the argument is that if you consider the institution to be unjust, then why not democratically elect that institution? Then why do we have Congress? Then why do we have a parliament? Then why do we have politicians? Then why do we send representatives of our ward or our community to represent us in a particular platform and say our grievances, and on the basis of which make laws, and then for us to determine whether or not we need to accept those or not, or interpret them simply or not? It's you're understanding the point. So it's very obnoxious from Dawkins' understanding that he considers simply not considers political actors in his enterprise. Now so basically, it is a crucial feature of an interpretive concept according to Dworkin that if one makes a claim about what the practice to which the concept refers requires, one necessarily takes a stand on the value of the practice. So, if I claim that the courtesy requires a man to rise when a woman enters the room, I am implicitly taking the view on what the value of the courtesy is. This follows simply from the fact that the community has taken up the interpretive attitude of courtesy. If the interpretive attitude is taken up in relation to some practice like courtesy, it is accepted that what that practice requires is sensitive to the value or purpose of that practice. So, when I say that practice requires X, I am always going to be taking the position on the value of that practice. You're understanding? So, for example, if I say that courtesy requires me to not try to have conversation about my private life when we are in public place, I might be implicitly assuming that the courtesy serves to value the fostering of privacy. But according to Dworkin is that if someone were to ask you to say what courtesy requires in a particular situation without taking a stand on the value of courtesy, you would be like a man so he says, you would be like a man at the North Pole who is told to go anyway but south. So Dworkin claims that in law, like a courtesy in his imaginary community is an interpretative concept. Because whenever we seek to determine what the law on a particular question is, we are always going to be making a claim about what the point, purpose, or value of the law is. So as I said, when you are considering whether or not I don't want to discuss about my private life in public, so I am implicitly assuming that courtesy serves as the value of fostering privacy. So his ideal is a very rights-based oriented model, which if you can notice from it, so how he distinguishes from Fuller and Nigel Simmons and Finis is that all these authors talk about a very singular dimension in law which they connect it to a very approximative matter, where Nigel Simmons come close to Dworkin in terms of only liberty that he talks about, but Dworkin has a rights understanding to what he ascribes to. So he says that simply because a law requires me or a courtesy requires me to not talk about myself in the public because I value the fostering privacy as a right for me. So this is much more important than an institution authorizing me to not to have a rule to not have private discussions public. You getting me? So this is where it also, if you understand Dworkin's perspective also, so he makes a little bit of a sense, because some rights are inalienable. Some rights are there which basically exist before an institution has given validity to it. But you need to understand that the rule of recognition that Hart talks about gives validity. It doesn't talk about the content or the ideal of the law itself. It gives validity to understand these broad consensus can be understood through the rule. So it's giving an authority through an institution that this rule exists. Let's say if today privacy as a law, privacy as a right didn't exist as a law in India, then it would have, then if you would have done something which was against privacy, then it would have been simply you are free to authorize it, because there is no horizontal applicability of the comparison of rights here. We are then looking at the perspective of freedom and privacy simply from the perspective of saying that if privacy was not recognized, then your freedom can trump over privacy, to say that you can basically barge into my life, intrude into my life, do whatever you want to do, I can do it because there is no law saying that privacy is something which is a law or not. So it makes sense from Dworkin's point of view in this way. So Dworkin points out, and he even writes in Law's Empire at page 93, and I am quoting what he has written. So he says that the most abstract and fundamental point of legal practice is to guide and constrain the power of government in the following way. Law insists that force not to be used or withheld, no matter how successful that would be in ends in view, no matter how beneficial or noble these ends, except as licensed or required by individual rights and responsibilities flowing from the past political decisions about when collective force is justified. So his theory is much more about the individual's rights and responsibilities that flows before a collective force is to be justified by virtue of a state. So you're getting me? So Dworkin's theory is a very individualistic theory, very rights oriented theory. So let's say someone to claim that one ground of law is what Parliament enacts, so what Dworkin's theory makes something of a proposition of law is that his account of grounds of law needs to be remembered. What kind of question this is for Dworkin is that law is an interpretive concept. So answering the question of what grounds law is not simply what Parliament enacts, which typical positivist might argue from Dworkin's point of view. However, I consider this to be a very controversial view because I object to this particular point. I say that as per Dworkin's question to involve an interpretation of legal practice, principally the practice of recognizing the enactments of legislature as law and the practice of following previous court decisions. So this may be what grounds law as per Dworkin, but to give validity to it, you need to have a rule, and you need to have a rule of recognition. You need to have a legal system. Otherwise, the distinction between a legal system in itself would extinguish. If we consider Dworkin's theory of rights possibilities are simple aspect of it, if you understand, because Dworkin says is a very individualistic process of it, because his sense is that collective force needs to be justified after your individual rights and responsibilities are adhered to, which is a very controversial claim, but this is what he says. Now, his account basically involves 3 stages of interpretation. The first is the pre-interpretative stage, where the stage involves the identification of rules and standards taken to provide the tentative content of the practice. Again, he's talking about the tentative content of practice here. He's not talking about the validity which the positivists talk about. They're not talking about content, they're talking about validity. In the second stage, the interpreter settles upon a justification of the main elements of the practice identified as at the pre-interpretative stage. In the post-interpretative stage, the interpreter comes to a better sense of what the practice really requires in light of the justification with which he has satisfied being the best. So that is what he calls it as a constructive interpretation. So, applying the strategy of constructive interpretation to legal practice, Dworkin arrives at a theory of law what he calls law as integrity. According to law as integrity, the law of a community consists of, in the most morally coherent justification of the community's legal practice, that isn't merely to restate that the claim is that law is an interpretative concept and that therefore in order to understand what it requires, one is to determine what the best justification of legal practice is. Rather, Dworkin argues that law has integrity by stating that on the best interpretation of legal practice, the point of legal practice is itself come up with the best justification of the community's legal practice. So his account is that the integrity in itself is relentlessly interpretative. And why it is so? Because it is both the product of the inspiration for comprehensive interpretation of legal practice. Unlike other theories of law, which equally must be arrived at by offering interpretations, since law is an interpretative concept, law as integrity is not merely an interpretation of legal practice, but also claims that law practice in itself is fundamentally interpretative. So, law as integrity requires judges themselves to engage in the process of constructive interpretation of the community's legal practice. They themselves are involved in it. Rather than simply considering the legal practice or the legal norms to be interpretative, the judges and the who are involved. So his theory is interestingly, Dworkin, if you can note from this particular point, what he says is that the judges plays an existential role in determining what community's practices best fits, and according to which this integrity is relentlessly interpretative, because it is interpretative from the point of view of how a judge is enacting a law. So his theory is only accounting for judges, not accounting for legislature, not accounting for citizens, not accounting for other legal officials, which is highly controversial. So now I will give a contrast of the modular conception and the functional conception of law from the standpoints that I have gathered my understanding in knowing. So on the face of it, if you look at Hart versus Fuller and his extension being Simmons and Finnis, so clear disagreement between Hart's model theory, which primarily distinguished by its mode of performing various functions to which it is put, and functional theory, which serves a very teleological specific purpose, is that if you look at the closer inspection of it, the difference is very thin. Thin how? It's because Hart accepts that law necessarily by its nature has the function of guiding, criticizing conduct, that it does so by the modality of primary and secondary rules. Fuller, Simmons and Finnis, on the other hand, talk about the function of subjecting conduct to the governance of rules through an approximation, which Simmons distinguishes from Fuller, and Finnis saying that in order to serve as the conduct of governance of rules, you need to also have equal participative goods that you must need to flourish in that legal system or that legal rules that you have. So the difference is that guiding is the function and the rules are the modality for Hart. Okay. Rules are, there can be various rules. There can be primary rules to basically say that whether you ought not to, or whether you need to do something or not do something. whether you need to smoke in public or you don't need to smoke in public. So those are primary rules. Secondary rules are something which is interpreting whether or not those primary rules are valid to the rule of recognition. So from a neutral standpoint, it is enforcing those rules from an adjudicative sense. So these are the modalities of the rules, because the rules are serving as different modalities here. The guidance is the function, because it is guiding a particular citizen to the conduct of governance of the rules. Fuller says that Fuller and the extension of the natural lawyers like Simmons and Finnis say that guiding by rules is the composite function. So there is no mode according to these three theorists. What I mean to say, guidance by rules is itself a composite function. Okay. Now the disagreement, if you look at it, basically both accept that guiding conduct by rules is central to the law's nature. Hart thinks that feature only goes part of the way to distinguish law from other kinds of things. Quite apart from the existence of rules, Hart importantly as the rules of any system gains their legal status by virtue of their actions, whether deliberate or not, of the officials of the system. So his focus is much more on the officials of the system rather than Dworkin's enterprise of focusing singularly on judges to point out a constructive interpretation to the law as integrity statement that he has made, and which I have clarified. Second is that in any legal system, the practice of officials gives rise to a rule of recognition which determines which rules are rules by law. So by contrast, these ideas seem to play little role in Fuller's theory, though they are logically consistent with it. Secondly, they disagree about the moral value of one law's model features. They disagree about the moral value of Fuller's 8 desiderata, and we will talk about this disagreement between, there is a Hart versus Fuller debate also. I'll talk about that in some other video. Now I'll come to Hart versus Dworkin's enterprise, because I have said that the functional enterprise is divided into two prongs. So there is one natural camp which basically says that law is a guidance of rules and it is a composite function. However, there is another camp of Dworkin and the interpretativist camp, which says that which basically says that it is not only a descriptive endeavor which a positivist might argue about, but it also, they look at how normatively one can justify a law. You can justify it through coercion, you can justify it through ideals, you can justify it through rights, liberties, and much more of these buckets, which comes from an individualistic point of view that makes the law as an entirety of it an interpretative model that best constructs how you need to have a interpretative attitude in the first place. So where there are three ways in which the positivist camp, who are by virtue of their rules, they are from their modular conception of rules serving as variety of modular functions ascribed to, distinguishes from the Dworkinian natural law camp, is that Hart does not share Dworkin's supposedly uncontroversial starting point. The law's function is to justify coercion. Of course, Hart accepts the law is often invoked as a reason for state coercion. However, Hart denies that the existence of sanction for the breach of legal obligations is a conceptually necessary condition for the existence of law. This is a topic that I will also discuss about in another video, about the conceptual obligation of it, part of it, whether or not legal obligations are moral obligations or not. For me, I consider legal obligations to be separate from moral obligations. There is Razian viewpoint also. I'll talk about it in some other video. Second is that Dworkin denies Hart's claim the law is necessarily depends upon the criteria identified by rule of recognition. There are disagreements. So he says that there are theoretical disagreements about what the law is in a certain cases, which law claims cannot be modeled as disputes about whether the criteria under the rule of recognition has been satisfied. So there are something within the law itself that itself is semantically thin or weak to justify the existence of a master rule of recognition to gain authority or validity over. So there is theoretical disagreement in itself of the rule of recognition there, that these rules, whether or not they satisfy with the rule of recognition or not. So this is also a very controversial point that Dworkin has made, and I discuss and reject this argument, and I'll do so in the later video if I can. Third is that Dworkin's view, it is necessarily the case that whether a proposition is a proposition of law depends even if wholly implicitly upon the conclusion of a moral argument. Hart says that this is a contingent matter, dependent upon the criteria contained in the rule of recognition. So you're getting me? So basically what the proposition of law wholly implicitly basically for him is that it depends upon a moral argument. For Dworkin. For Hart is that it is a contingent feature because Hart doesn't disagree that morality exists or not. Hart says simply if the rule of recognition as a contingent feature, if it allows morality to exist, then it exists, which is an obvious sense. Because I'll give a simple example of how before Puttaswamy did we consider privacy to be sort of an inalienable right which we considered in India to be a law. No, right? Because after Puttaswamy, after the court's decision, judge's interpretation, then the legislature through its master rule has considered the Article 21 to be given such a space. So here you can argue that judges made the constructive interpretation to fit the particular notion of privacy into the constitution, which was elected to not simply include privacy as a ground, but you needed to have the privacy law in its separate existence to give guidance to the conduct of the citizens to exist by virtue of those rules. Imagine if you simply just said that privacy is an ideal that you need to consider and simply consider it to be existed, then to what extent would basically a individual would ask for consideration? So basically, if I would say that if I do cyber hacking or something like that, and if I hack into a system, which means that my privacy needs to be protected because I say that hacking is ethical to me. You're getting me? So that's obnoxious. So here Dworkin he fails to understand this point. Now, if you look at it, the first argument is simply that it is only the explanation of the phenomenon of theoretical disagreement. To the extent that this argument fails, as we later suggest it does, this undermines Dworkin's position of his third disagreement, which I talked about right now. So Dworkin's second argument seems to rest upon a general thesis that the only way to interpret social practice is to engage in the process of constructive interpretation. The thesis is quite distinct from the claim about theoretical disagreement. So basically what we are saying is that we are not simply buying into Dworkin's claim about interpretation. Why? Because Hart, though he may say that he provided a poor description of the nature of law, the converse can also be true. But Hart doesn't discount for the theoretical disagreements through which he says that the validity of a law or a rule of recognition simply exists as a contingent feature necessary for a law's morality to justify in its rule of recognition. He simply says this, it's a contingent feature, not a necessary feature as a law, which Dworkin would consider it as holistically that law is an interpretative model and it's a part of morality. That's very obnoxious, because if you don't have the considerations and the guidance required to consider those rules, to consider how you need to be governed in a framework, then simply saying that you have privacy would not make an ethical distinction between a person misusing the law and the person using the law for just purposes. That is my point. So this is getting long, 48 minutes, so I'll stop here and I'll release a part 2 of the video where I'll talk in brief about the fallacies of Dworkin through the understandings of the modular and the functional conception of law that I have made. So thank you very much for attending this lecture, and I'll see you in the part 2 right now.